Hello, my name is Ali Zaidi. I am a solicitor and partner in Edwin Co Law Firm. We are a corporate commercial practice in the heart of London, opposite the High Court in Holborn. I head up the litigation department, and my particular specialism is insolvency. What I want to talk to you about today is a very recent decision which has a major impact on accountants and directors, but in particular accountants in the sense of the advice that they give to their director clients. This case is called Sequana, and it's all about what is known as the creditor interest test. And effectively, this is a decision which redefines what is meant by insolvency and the duty on the director where a company becomes insolvent. And just by way of background, Sequana was a very common situation where a subsidiary company had a substantial cash pile which it was contemplating paying by way of dividend to its holding company. But at the time that it made that decision, it was on notice of a potential claim from the Environmental Protection Agency, but the claim hadn't crystallised. In fact, the claim didn't crystallise until 7 years later. But of course, 7 years earlier, the directors made the decision that they were going to pay the dividend up to the holding company. So, the dilemma faced 7 years later was, should the directors have paid that dividend 7 years earlier, knowing that there was a potential claim, but the claim itself hadn't crystallised, and didn't crystallise for 7 years' time? Now, prior to Sequana, the legal position has been long established that a company becomes insolvent, i.e. balance sheet or cash flow, and in that situation, then the director's duty switches from acting in the best interest of the shareholders to instead acting for the best interest of the company's creditors. This is what's defined as the creditor interest test. So this is the issue that was being considered in Sequana. And what the court decided was, well, actually, the question of insolvency arises not just when the company is insolvent, but actually when the company is likely to become insolvent. And likely means effectively, probably, or imminently. So, pausing there, if you think about that, that's quite a shifting of the goalposts. Pre-Sequana, the director's duty to act in the best interest of the creditors arises when the company is insolvent. Now, it's when the company is likely to become insolvent. Of course, how do you define that? I mean, there could be any number of scenarios where you could have potential claims that have not yet crystallised. Typically HMRC, for example, they may have commenced an investigation. They may have possibly even raised APNs, which the company or the directors have decided to challenge. There may be potential claims by employees, by creditors, by a landlord, by a supplier, all of which the company disputes. So on the face of it, there is no crystallised debt. But what Sequana is saying is, effectively, if the director thinks that there is the likelihood that this claim is going to materialise, and if it does materialise, it's then going to cause the company to become insolvent, then the creditor interest duty kicks in, and the director has to act in the best interest of the creditors. So think of it like, for example, you're driving a car into a tunnel. The tunnel represents insolvency. It's that darkness of doom and gloom. How am I going to get out of this? In that situation, the director has to be thinking, what do I do in the best interest of the creditors? How do I minimise those losses? How do I turn this company around? But as you progress through the tunnel, you start to see the light at the end of the tunnel because you are turning things around, then the interest shifts back to acting in the best interest of the shareholders until you finally come through the other end and you return to solvency. So, why is this important to accountants? Well, for two reasons. One, because obviously accountants have to advise companies and directors on whether a company is insolvent. But in doing so, what Sequana teaches the accountant is you have to give very careful consideration as to whether there are contingent or prospective liabilities which could make the company insolvent. Now, why is this important to accountants? Well, two reasons. First of all, when advising companies and directors upon whether a company is insolvent, you now need to consider Sequana. you need to be considering whether those prospective or contingent claims that the directors have made you aware of are likely to materialise, and if so, will they cause the company to become insolvent? But there's a second reason why this decision is important, which is advice given to the directors themselves, because what Sequana is doing by shifting the goalpost is basically exposing directors to potential future claims if the company later enters into a formal insolvency process. Because, of course, any liquidator looking at the company's affairs is going to say to the director, well, okay, when you became aware of this large contingent claim, for example, from HMRC or from the trade supplier or from the disgruntled ex-director stroke employee, how did you measure that for the purposes of preparing your accounts? What prospective contingent liabilities did you make for it? And so the director potentially is at risk if he can't justify why, knowing what he knew about a potential claim, he made no contingency for it, then the director is a personal risk or personal liability to the liquidator on behalf of the company. So again, it's important that accountants are aware of this and are able to advise their director company clients accordingly. So I hope that helps. I hope that gives you a snapshot of what Sequana is about, and in particular the creditor interest duty, and more importantly, forearmed with and forewarned with that information, you're now in a position to advise your company clients and directors in particular about the contingencies that need to be made when preparing accounts and the potential risk to them in failing to do so. Thank you for listening.